Good afternoon, everybody. My name is Steve Jewett. I'm a county court judge in the Ninth Judicial Circuit of Florida, and that's in Orlando, Disney World. Next.
Good morning. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada.
And good morning from Oregon. I am Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals. Very excited to hear you this morning.
Students.
Hi, I'm Sophie Brager, and we are presenting We the People Unit 5.
Hello, I'm Andrew Davis.
And I'm Tamara Singleton, and we are representing Unit 5 of Mr. Phillips' AP Government and Politics class at Robert C. Byrd High School.
And that's West Virginia Wild, correct?
Yes.
Correct.
All righty. Well, we are here Unit 5, and we're doing question 1 today. Question 1. It reads as follows. A result of the decision in Wisconsin versus Yoder is that, quote, any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs, end quote. Do you agree or disagree with the result of this decision? Why or why not? In addition, what words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And then finally, how have courts balanced religious beliefs with other rights? You may proceed.
Parents should be the ones to determine what they want their child exposed to, but they should take into consideration the effects of the decision on the child's development. The court ruled that the individual liberty to worship freely outweighed the state's interest in forcing students to attend school. This ruling only takes into consideration the adult's belief, excluding the children's right to decide. Children should have a say in matters regarding their education if they are over 14. In states like Georgia and West Virginia, children over the age of 14 have the option to choose which parent they want to live with during a divorce. The option given to children in those two states proves that the age group is responsible in making other important decisions. In Tinker versus Des Moines, the Supreme Court held that children have rights and do not lose those rights when they step onto school property. Thomas Jefferson greatly believed education should be free from religion and ideology, stating the one of instruction in the various creeds of religious faith existing among our citizens presents a chasm in general institution of the useful sciences.
Nothing is explicitly said regarding education, but it does fall under the Equal Protection Clause of the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, preventing laws from taking away the right to education. In the West Virginia Constitution specifically, Article guarantees the right of a thorough and efficient system of free schools. Other than that, no specific statement is made protecting the right to an education. There are pieces in regard to how the education run with funding from a school fund supported by the legislature. In respect to Wisconsin v. Yoder, though parents are responsible for their children and it's not unconstitutional to pull them out of school or educational system, but personally, it seems that it should be. The students should decide when their educational needs have been met despite personal religious concerns.
When it comes to the balance between religious beliefs, practices, and other rights, knowing that the relationship between the two are fluid and always changing upon different interpretations. Under the Free Exercise Clause under the First Amendment in the Constitution stating that Congress shall make no law prohibiting the free exercise of religion, the foundation of religious liberty was born from the founding fathers yearned to foster and defend freedom of religion. Courts have always interpreted the Free Exercise Clause with caution because they take into thought not only actions that are religiously motivated, but limitation to the laws it's clashing with. In the 63 decision, the Colorado State Constitution was declared violating the Equal Protection Clause in the case such as Romer versus Evans of 1996 that dealt with both religious beliefs clashing with laws and policies of the state.
Okay. Doreen, who's reading? Who's got the first question?
I had the first. For you guys.
What do you think separation of church and state means in the context of a child's right to an education?
That's a good question. I think For me, it means for public schools at least that education should be completely separate of religion. Not that we shouldn't learn about religion in schools, but that we shouldn't practice religion in public schools.
I agree with Sophie. I feel like learning of different religions helps expand the child's information and brain in general, but knowing and practicing the religion would just overstep that line. And I feel like that would be that line of learning and practicing.
I agree, but in a way, I also disagree with both Kamira and Sophie, because I know some schools, such as our own, have Fellowship of Christian Athletes, where it's mainly student-led with maybe an advisor who helps they learn about the importance of some religions, and like they'll have some prayers before games, student-led, not forcibly though. It's all voluntary.
Okay, I have a follow-up to that if I can. You had indicated, and I think it was Sophie said, and maybe Tamara also agreed, that you think it would be okay to learn about religions in school, but not to have the schools, pick a religion or force a religion on you. How does the school then select which religions to teach you without, in essence, choosing the ones that are the most legitimate? Or I mean, how does that happen that they're not then establishing those religions that they're teaching you as better than the ones they don't?
I think that teachers should teach as many for world history classes. They should teach about different religions around the world, but I don't think that schools should keep a Bible in the classrooms or have crosses in the hallways, like that separation between the church and state.
I'm gonna go off Sophie when she says in world history, if you take that for example, I feel like understanding where the empires like their foundation, because I know a lot of empires foundation was religious based. That's how I learned most of multiple different religions, and I'm thankful for that. So I feel like putting the religions and connecting them to empires and government based stuff, I feel like would help, not focusing on one major one, but just continuing on the lesson throughout the history. But I also do agree with Sophie when she states how crosses and Bibles, I feel like should not be in the classroom. I feel like that just crosses the boundaries of separation of state and church.
Like what with Tamira said about how learning about the different religions is beneficial because you have more experience with the knowledge about the empires and everything. It's also beneficial because it allows the student to form their own opinion on what they want to believe in. Knowing the origin of each religion and how it derived, they can go interested in it, and then can research further, and then that might change their views in that way. So it allows the freedom to form religion from educating them on the religions.
Let me take you a little bit different direction. In your prepared remarks, you gave a number of concrete examples in which the legal system has recognized the rights of children or youth. So how do you think, or do you think the rationale of Wisconsin versus Yoder would extend to the criminal context? Say, if police were investigating a child for criminal conduct and wanted a DNA sample, and the child did not consent to the search, but a parent said, "Oh, take my child's DNA." Is that something the Constitution would allow, in your view, under Wisconsin versus Yoder or similar thinking?
That's a really good question. I think that those two situations are a little bit different, because one is a criminal offense and one is the right to an education. I do believe that the child should have rights, but I feel like um, in that case, the guardian, if they are under the age of 18, the guardian should have a say in the criminal offense of their child.
I agree when Sophie states how they're kind of two separate things, but with Wisconsin versus Yoder, I agree with what was brought towards the court, but failed to fully consider the rights of the child when the child should get to have say in their education. So the right to an education and the right of with the criminal based, I feel like it's just two different things. But I also agree that in a stance of the parent is in charge of their child until, well, medically until their age of 18. So I feel like at that moment, the child does not get to have a say because in the end of the day, they're not in charge of them medically. Angie, would you like to add on? I apologize.
Oh, no, you're good. Yeah. So I do agree about the difference in severity of the two cases, but thinking strictly like they did in Wisconsin versus Yoder, it would be the parent's ultimate decision. And even in today, if someone under the age of 18 is arrested, they are told legally not to say anything until the parents arrive because they aren't at that point in their life where they make fully their own decisions quite yet.
So in your prepared remarks, you mentioned Tinker and the holding of kids or children or students do not lose their rights when they step onto a school campus. How do you feel about schools requiring their students to be vaccinated?
That is a very good question. I personally believe that students should be vaccinated. And I know that people are sometimes against vaccinations, but I think to protect the overall body, it's important that people do have vaccinations, even though they might give up their right. It's hard to say, but I think in order to keep people safe, that we should have vaccinations in schools.
This, I believe, kind of clashes because one, you could look at it as, oh, I have my individual right of saying no to the vaccine, but at the same time, you're wanting to do better by the whole group, which is kind of like a hint of classical republicanism, which is also one of the founding layers of our nation. So really just clashes like, oh, if I have the right to say no, yet I want to make sure everybody else in the school system is protecting my child. Like, it's just like asking the question, when is that white line crossed? Like, I agree. I agree with Sophie when she said it's really hard to answer that at the moment.
I would like to add that I do feel like it's a very sensitive question, especially right now with what's going on. But it's kind of similar to the last question asked, it's very different in severity. Because in Tinker versus Des Moines, it was all about freedom of speech and just being able to represent something you believe in using armbands. But with the vaccination, it's not just about one student's freedom of speech, it's about protecting the whole student body from a potentially dangerous disease that could spread. So vaccinations would be important there.
I would also like to add, sorry, that in Tinker versus Des Moines, the reason why the children don't lose their rights on the school property was because that it didn't go against, or it wasn't against the school, like in that it wasn't hurting the school in any way. But
it was infringing on other rights.
Yeah, but I feel like not. Oh, sorry.
Time.
Yeah, I didn't notice that the time was almost up, and I had about 3 more things I wanted to ask you guys based upon what you said. As I said, I'm a judge, so most of the time I do the talking, or or I'm telling people what to say or not to say, or to stop talking. But I'll tell you, these things I've done nationals a couple times, and to me, the good ones are the ones that's like a conversation, and I'm interested to hear what the person says, and then I want to engage them. And I was right there. You guys, I really wanted to talk to you some more and ask you some more questions. I mean, I liked your opening statement. It's like kid power. We are strong. We can make our own decisions. The one thing that was concerning to me is you said that, and then you were like, well, but if it's like a criminal thing, it's not gonna, you know what I mean? To be kid power. Come on, you can make, if you can make the decision to go to school or whether to, what your religious beliefs are, then I think you can make that decision. But you guys did a great job. I really enjoyed it.
I agree. Good job. I enjoyed your written comments, especially the examples that you gave, your references to the various Supreme Court cases. I also, with regards to your responses, you all were very thoughtful, and you each had your own opinions, even though Sophie and Tamara agreed a lot, but you still had something different to say and share, which was good. And I liked, Andrew, your example with regards to the practice of religion, if it's student-led versus school-enforced. I thought that was a great example. I also enjoyed your distinction too, and your take on religion being taught in the schools, that it should be taught in the sense of from an educational viewpoint, which is very different from requiring someone to follow any particular religion. And so I thought that was well thought out and a good distinction. Good job.
So I'm a judge too. I would totally love seeing people with your skills show up in our courtrooms. My job is primarily not talking, it's asking questions, and having responses like the ones that you gave us are it's just so helpful from a court's perspective. So much to like about this team. Your dynamic you were very much a team. The way you shared time, you were respectful of each other. I don't know if this was planned or not, but one thing I thought worked really well about your dynamic is it seemed like Sophie and Tamika would take a question and kind of go theoretically, and then Andrew would sort of come back to the exact question and say, well, for example, on the criminal case, Andrew's like, well, to answer the question exactly, if we extended Wisconsin versus Yoder, kids would be toast, basically. And I thought that among the three of you, the ground you covered was amazing, particularly that there's only three of you. Some of the lines I love, Tamika, you had kind of, oh, that's a hint of classical republicanism as you shifted from the individual rights perspective to the common good perspective, bringing in your Unit 1 skills. It was all just very deft. I thought in a way that as my fellow judges have said, really made me just want to keep talking to you about these very, very important issues. So thanks.
One thing that I wanted to bring up though, and it's first of all, I actually wrote down republicanism. I thought that was great. I really did like that. But one thing to be careful about, Andrew, is your opening statement. It's clear that you're reading it. You weren't even looking at us. You were looked over this way and you were reading, so you didn't even have your eyes on us. And I know that the Zoom kind of lends itself almost to allow that, but I know that when this is in person, if you were clearly reading or something, you would get a major deduction for that. So be careful about that, okay? But other than that, fantastic. Like I said, I've got another 10 questions, but unfortunately we got to go. Good luck, you guys.
Yes, good luck. Good job.